You know, it seems like every year at Thanksgiving, somewhere between the turkey and the pecan pie, somebody corners me with a legal question. And for the most part, I don't mind because I actually enjoy being a lawyer, and most of the time it's a fun question. So this year, I was fully expecting the question to be about the Trump administration and one of the many, many laws that they've broken. Sorry, MAGA, if it's true. But no, this year it was an in law. And he said, hey, I know I need a will, but how much money do I need to have before I should consider a trust? Like, am I rich enough for that yet? And this is actually a question that I get a fair amount. There's this deeply ingrained myth that trusts are only for the Rockefellers. They're only people with their yachts parked inside bigger yachts that are parked outside Monte Carlo. That's not really the case. So today I'm going to give you the exact answer that I gave my in-law, and it's probably going to surprise you at least a little bit because the answer usually has very little to do with how much money is in your bank account right now. Hi everybody, my name is Ryan Reifert. I'm a business and estate planning attorney in San Antonio, Texas. And if you watch this video and you like what I have to say, I'd appreciate a like and subscribe, yada yada. So back to the Thanksgiving question. How much money do you need before a trust makes sense? And to answer that, we have to separate trusts into two main buckets, right? Bucket number one is the revocable living trust. This is what 95% of people are talking about when they're talking about a trust. Then you have the other bucket is irrevocable trusts. That's the bucket that's stereotypically for people with yachts parked inside bigger yachts parked outside Monte Carlo. So, bucket number one. For a revocable living trust, there's basically no minimum dollar amount required. You could have a house worth $300,000, some retirement savings, a bank account, a 401k, an IRA, a Bitcoin or two, and a trust might still be your best option. Why is that? Because a living trust isn't about estate taxes. It's about estate efficiency. If you only have a will in Texas, when you pass away, your family must go to court. That process is called probate. And it essentially boils down to the fact that a dead person can't sign legal papers. And we have to get a judge's order in order to transfer the dead person's property. You're required to have a lawyer. You're required to have various public filings. Everybody knows what was in the estate. You get a bunch of junk mail. We want to buy grandma's house. We want to do an estate sale, yada, yada, yada. Texas probate is a whole lot easier than a lot of other states. You'll hear stories of, oh my God, you have to do a living trust because it's going to save you $50,000 and probate is a nightmare. That's true in some states. Most of the time, that's not true in Texas. Texas has a very fast, very efficient probate system, but it still involves hiring lawyers, paying filing fees, delays before your family can access the accounts, and most importantly, it's all public record. Anybody who wants to look it up can see what mom and dad owned and can see who got what. Living trust allows your family to skip the courthouse entirely. It's private, it's immediate. It saves your family the headache and expense of an administration after you're gone. So you don't get a living trust because you're rich enough to get a living trust. You get a living trust because you want to make things easy for the people that you love after you pass. I would be remiss if I didn't mention that living trusts come with their whole own set of potential headaches and pitfalls and problems. And there's a lot of things that you can read about that. I may do another video on that in the future, but for now, I'm going to leave it at this. If you're going to do a living trust, you need to call a lawyer. Don't try to do it yourself. Don't let your financial advisor do it. Don't let your brother, who was a paralegal once for 6 months, do it. Call a lawyer. The cost of getting it wrong and having to go back and fix it later is significantly larger and significantly more prohibitive than just doing it right the first time. Now, let's look at bucket number two, the irrevocable trusts. These are harder and in many cases impossible to change once they're set up. When do you need an irrevocable trust? This is where the question of the amount of money actually does come into play, although it's not just amount of money. There's a couple of other circumstances that can play into this. You have specific missions for irrevocable trusts. Mission number one is high net worth families. Right now, under federal tax law at the moment, we're talking about approximately $14 million per person. That means if you have $14 million for one person and you pass, you pay zero in estate tax. If you have between a couple, $28 million or less, and you elect portability on the first person to die, and that step's important, we'll talk about that in a future video, you pay zero in estate tax. Now, If a husband and wife have a combined net worth over roughly, I'm going to say 22 to 23 million, then yes, we need to start talking about sophisticated irrevocable trusts. But Ryan, you just said 28 million. Now you're saying 22 to 23 million. Why is that? Well, if you have 22 to 23, and I've had enough clients who are there, you're going to get to 28 with 90% certainty. You're going to be at 28 within a few years. So it's time to start talking. It's time to start planning in advance. You're far enough under that amount that some advanced planning is really going to save you some money, is really going to be tax efficient. But money isn't the only reason for bucket number 2. We also use irrevocable trusts if you have special circumstances, regardless of your net worth. For example, maybe you need to qualify for Medicaid to pay for a nursing home without going broke first, right? The admission standards for Medicaid, you have to have essentially $0 and essentially zero income. If we have a Medicaid trust, we can change that a little bit. Maybe you have a child with special needs and leaving them an inheritance directly would ruin their government benefits, would leave them open to exploitation. Maybe you work in a high-risk profession and you're worried about future lawsuits and you need serious high-grade asset protection. For all of those things, we're talking about an irrevocable trust, and it doesn't matter whether you're a Rockefeller or you park yachts inside of yachts outside of Monte Carlo. So, back to summarize my Thanksgiving dinner answer, you don't need millions to need a trust. If you just want to keep things private, you just want to keep things out of court, you want to save a few grand on a probate, a living trust is a great tool for just about any homeowner in Texas. On the other hand, if you are knocking on that $28 million number or in the teens as an individual, maybe you have specific considerations like Medicare, like special needs, like asset protection for high-risk professions. All of those things are very good reasons to talk about irrevocable trusts. So, moral of the story, don't determine your estate plan based on your bank account. Determine it based on what you want to happen with the people you love after you're gone. As always, thank you for tuning in. Like, subscribe, and I hope to see you all again soon. Take care.